We're back in the Special Committee on Impeachment Inquiry, and we are next going to be spending some time with rules and procedures of the Special Committee on Impeachment Inquiry. And I believe we have two legislative counsel on this, Michael Grady and Jen Carby. Just by way of introduction, this is different kind of work than our normal legislative work. And we felt that it was important to lay out, as actually is instructed in the resolution, House Resolution 11, that we establish procedures and rules. Since this is an investigation, which is a little bit different than our normal committee work. And these are the rules that we've established. And if Mike or Jen can give a little background of kind of where we drew from and how we arrived at this, and then we can also walk through, and I'm sure that there will be lots of questions, and that's fun. So.
Sure. So again, Jen Carby, Director and Chief Counsel at the Office of Legislative Counsel.
Michael Grady, Deputy Chief Counsel, Office of Legislative Counsel.
And so as the chair said, these are draft rules and procedures that we'll go through, but some of the structure of the rules and some of the topics that they covered are pulled from some examples that we got more recent than 1976 examples from impeachments in Connecticut and Illinois. Early 2000s. And so really taking those and then using a kind of our Vermont lens and how we approach things here and using our procedures and also looking at whether and to what extent this was going to be an adversarial investigation process, which is what those in those other states which were looking at impeaching their governors had been, or really more of an evidence gathering, kind of the way Betsy Ann was setting it up earlier, to have this committee really looking into doing the investigation and inquiry into whether there is sufficient grounds to believe that impeachment is warranted. And so that's really the approach that's taken in here. All right, so it starts out, do you want me to put it up on the screen? I did.
So we can be on the same page, so to speak.
Right. So this would have the special committee hereby adopting the following rules and procedures to apply to the receipt and presentation of evidence for your inquiries into whether, and this is using the language from the resolution, sufficient grounds exist for the House to exercise its constitutional power to impeach the Franklin County State's Attorney or Franklin County Sheriff, or both, pursuant to the authority in H.R. 11. And do they?
Sure. The chair of the special committee has the authority to call the meetings of the committee, call the committee to order, swear in witnesses, designate the order of business, generally supervise the special committee. No action shall be taken by the special committee at any meeting unless a quorum is present. The majority of the members constitute a quorum. You give notice of the date, time, place, and subject matter of the committee's hearings as soon as practicable for commencement of the hearing. And a hearing and any action taken at a hearing shall not be deemed invalid solely because of the hearing is not given in accordance, solely because notice of the hearing is not given in accordance with this rule. Now, hearings of the special committee may be closed to the public. You have the authority under the Constitution to regulate the proceedings of the legislature, and you can establish how those proceedings are conducted. And you may hold those proceedings in executive session with 2/3 of the committee members present and voting. Determine that confidentiality is required to protect witnesses from potential retaliation because the matter is related to a witness's ongoing employment, because the matter is related to another ongoing investigation, to consult with the special committee's attorney or attorneys, to prevent the disclosure of information that is confidential under law or is confidential under Section E, or as otherwise necessary to enable the special committee to conduct its inquiries.
So before you go on from that section, I think that's probably quite an important provision for transparency, but also for protection of witnesses, of potential victims of these issues. Could you go over a little bit of what kind of obligations the legislature has legally as far as does an open meeting law apply to the legislature? Or if you're not prepared to do that today, but I'd certainly want to understand a little bit more about the scope of our authority to go into executive session.
So generally, the opinion of the Office of Legislative Counsel is that the open meeting law as drafted does not specifically apply to the General Assembly. If you were to try to implement all the requirements that are in the open meeting law to the General Assembly and its proceedings, you wouldn't operate because you change your agenda daily, you change your schedules weekly. You cannot comply with the notice requirements of the open meeting law in the way that you operate today. In addition, when you look at the definition of the public body, which the open meeting law applies to, and you compare it to the definition of public agency, which the Public Records Act applies to, the definition of public agency in the Public Records Act references the branch, and each branch, an office of each branch, an instrumentality of each branch. The definition of public body does not. That's why the open meeting law doesn't apply to the judiciary, because the judiciary can adopt its own rules and provisions about how it allows the public. And you, as a separate branch, because public body definition doesn't apply to branches, you can set how you are going to allow the public to have access as the Constitution requires, because it provides that the doors of the legislature shall be open to the public unless the public welfare determines otherwise. And you do have provisions in your rules now which provide when meetings are open, who has control of a committee room, when certain provisions or meetings of the General Assembly or its bodies are not open to the public, such as the ethics panel in the House, the sexual harassment panels in both houses. You specifically provide in your rules and procedures adopted by those panels that certain proceedings of those bodies are not open to the public. And you can specify here what provisions or what subject matter or what hearings at all are going to be open to the public or not. Now, someone that's going to argue that the open meeting law does apply to the General Assembly is going to look specifically at 1 VSA 313, which is the executive session authority for any public body to go into executive session. There's a provision in there that says, and I'll just read it directly, that the Senate and House of Representatives, in exercising the power to make their own rules conferred by Chapter 2 of the Vermont Constitution, shall be governed by the provisions of this section, the executive session law, and regulating the admission of the public as provided in Chapter 2, Section 8 of the Constitution, transparency of government. Well, that's great, but that also has the caveat that in exercising the power of your rulemaking authority, and one General Assembly cannot limit the rulemaking authority of the subsequent General Assembly. So when the General Assembly enacted 1 VSA 313C in, I think it was like 1987, it cannot limit your authority to exercise your constitutional rulemaking in 2023. So you are not bound by the executive session law. And if the open meeting law did apply to you, why do you even have this subsection in the executive session law? You wouldn't have to, because you would be a public body that's governed like every other public body under the open meeting law. So again, to summarize the opinion of the Office of Legislative Counsel, for as long as I've been at Legislative Counsel, which is over 20 years, has been that the open meeting law doesn't apply to the General Assembly because of the text of the open meeting law and because the constitutional authority for your body to come up with its own rules about its own administration and operation.
Thank you. So just to, follow up, I mean, we certainly want to be as transparent as possible. But there are, and this is something that's going to be quite different than our normal committee work, where it's very unusual to ever go into executive session. But here, if not going into executive session could potentially undermine what we're trying to do in this investigation, we're in a bit of a different kind of situation. And we also have to be cognizant of making sure we're protecting witnesses from retaliation or from any employment issues. So that's going to be an interesting balance as we go forward. And we will make that judgment call as we are going to be bringing forward certain witnesses. So just wanted to flag that for folks, that's a pretty important provision of these rules. So any questions on that? Yes, Representative Dolan.
Can you clarify exactly what the difference would be in executive session? Would it be just us and whoever is sharing information, and we would ask everybody else to leave? Would, I'm assuming would not be, live streamed, like.
Correct, all those things.
Okay.
It would be just witness, even in that situation, and these are some logistics that we'll be talking about later, that if we have a witness, we will still be presumably making a recording, just in case down the road, if we get to articles of impeachment and we want to have a recording of that, if we make it to the trial in the Senate. So those are some logistics that we have to work out. But as far as, the public would be excluded. That's what that means as far as going into executive session. Did I miss anything on that? Was that?
Generally, before you go into executive session, you have to meet in public session. You have to basically read a motion to go into executive session and set forth the basis of going into executive session. And then when you come out of executive, and during executive session, you can't take any formal action of your committee. But when you come out, you just generally summarize what you did, which is these statements, such as we heard testimony from witnesses regarding X. And that is effectively what the process for going in and out of executive session. And you can bring into executive session staff and other persons that are integral to the operation of the committee.
Other questions? Yeah, go ahead.
So, assuming we adopt these rules as written, I would assume that we would be striving for consensus, but the 2/3 in this instance of the committee would be 5 out of the 7 that would need to vote.
Correct.
Okay, the next provision allows the special committee to hire an independent investigator to conduct an investigation into one or both of the respondents, and allows the special committee to hire outside counsel to assist this committee with its work. The section C allows the special committee or its investigator to request that a respondent or other witness provide documents or other information. And it also, pursuant to that language in the resolution, allows the special committee to subpoena or authorize the investigator to subpoena the attendance and testimony of witnesses and the production of documents and other items as the special committee deems necessary to conduct an investigation. And production of documents or other materials pursuant to a subpoena ducis tecum requiring the production of documents or materials will be made at the time and place indicated in the subpoena. The special committee may require the immediate production of subpoenaed materials to any authorized representative of the special committee as identified in the subpoena. And any person who is served with a subpoena to attend a hearing of the special committee shall also be served with notice that the person may choose to be accompanied by counsel and a committee representative or other support person.
So at any hearing at which witnesses are to be called before the special committee, the following rules and procedures shall be applicable to the hearings held for that purpose.
So before you, I apologize, backing up on the subpoena process. First, I'll make sure as we go through, we'll stop and ask questions as we get to each of these provisions. So in your experience on other like ethics or discrimination panels and such, how often should we be expecting to actually use the subpoena power? I would assume, let me back up, I would assume in most instances, we just will request and have a witness show up. We don't have to subpoena everybody, in other words.
No.
It may just be somebody who may be reluctant to show up, or if we are finding that somebody doesn't show up, we can then subsequently subpoena the person. Is that about right? Is that how that works?
So I've staffed some of the investigatory panels for the legislature for 5 to 10 years, if not more. There's only been one situation where the subpoena authority was even really contemplated, and it was a reluctant witness. And that witness, she hired an attorney, and the attorney advised her that the best thing to do was to cooperate, and he would be there to help her in her testimony. So it came close, but ultimately it never was issued. So there were discussions in other special committees previously as well, and I don't believe those committees ever issued subpoenas either.
I think sometimes having the authority and the ability to issue subpoenas is enough to get cooperation without having to actually issue.
And the legislature as a whole has legislative subpoena authority, and it can delegate it to entities such as HR.
And one other question, and then see if other folks have questions. If you subpoena a witness and they don't show, I mean, what's the consequences of what can be done in that situation?
There is 2 VSA 22, which sets forth the process for legislative subpoenas, and it sets forth, my fat fingers. If they do not comply with the legislative subpoena, a superior court may compel the attendance of the person, the giving of testimony, and the production of papers or other evidence as required by the subpoena. They may refuse on the grounds of a valid privilege, but that will be something that the court would also review. Does that answer your question?
Yeah, no, I think so. Other questions?
So some of the items that were mentioned in HR 11 are currently the subject of ongoing investigations from other bodies, or maybe. So does our ability to subpoena documents necessarily mean that we will get access to those documents if they're related to an ongoing investigation, or will that be something that has to be kind of negotiated through the court process?
So that you could bring Beth in. Honestly, I don't know if you get to the subpoena. And Beth, you want to come up on this or not? Because I think most likely you would request the information from that investigatory entity, and that investigatory entity would assert some privilege or exemption. And then you would have to determine whether or not you were going to really assert your legislative authority. I think in most instances, the investigatory entity will be asserting something that's valid, and you'll have to make a decision of whether or not you want to pursue that subpoena.
You didn't need me at all. That's St. James Office of Legislative Counsel. That I totally agree with everything Mike just said. I think it depends on the entity. It depends on the investigation. And I can think of a handful of entities that may be investigating some of the conduct that you all are looking at. And there's going to be a lot of valid objections or privileges asserted. But that doesn't necessarily mean that that's a bar to information sharing. in general. A lot of that might be able to be negotiated.
So in a subpoena, would we know that certain documents could be, or would we be confidential in that kind of situation? If there's an investigation going on, if there's, maybe it doesn't require a subpoena, maybe it's just, we're going to treat those documents as confidential.
Remember that some of the investigatory entities might be separate branches in and of themselves, and that they will assert that their constitutional authority to work within their separate rulemaking. And they might not even acknowledge that they have an investigation ongoing. You would request that all their records be related to an investigation, and they might not even acknowledge that one exists or not. And I don't know at that point what you would do. That we'd have to discuss that at that point.
Something we'll have to navigate. Representative Dolan.
But just kind of on this piece of it, we were talking about negotiating and have to figure out, like somebody says, no, I'm not going to provide this, I have some privilege. And we could say, well, we hear that, but, we think we still get, who is the person? Is it the whole committee? Is it the chair? How is that negotiated?
So whether or not to pursue the subpoena or not.
Yeah. Like if somebody says, no, we have special privilege, we don't need to give that to you. Like, how is that whole thing negotiated?
I don't believe HR 11 says that it needs to be anything more than a quorum, majority vote.
I mean, are you asking me sort of from a practical standpoint? I think, staff, legal staff would be consulting with the chair or with the committee in executive session to talk about whether you wanted to, what the likelihood of success was if you were to try to pursue through the courts to enforce the subpoena if there was valid.
Can I add something practical? Is that all right?
Please.
When you're thinking about requesting documents from another body that's doing an investigation, there may be documents that they created, but the likelihood that you are looking for a document that they have just collected is high. And the fact that another entity holds that document does not stop you from going to the source and trying to collect that document, which is that you are an investigative body, right? So when you're looking at like a civil trial and a criminal trial, those attorneys are not most likely not getting together and sharing information, but they probably have a lot of the same witnesses and documents because they went to the source. So the likelihood of you getting the information you want, just not through that other investigation, is high, depending on what you're looking for. Does that make sense?
Yes. And just to be clear as well, in the language, it's the special committee is subpoenaed, so it would be both lines, like the whole committee issue subpoena.
And then to address if somebody comes back from a subpoena saying that we have special privilege, we as a committee would then figure out how to respond to that.
Right. Yeah. Yes.
And then I did have another question just around the, I don't know if it's confidentiality, public aspect we talked about. We can go into executive session, but then on our, does it need to be public record of who we are bringing in as witnesses and who is speaking to us, even though the content of it could be an executive session? Is there any difference in that?
Well, we can skip ahead to subdivision E here if you would like.
It's coming up, that's great.
Okay. I think I got to D1.
Yes.
Yes.
So testimony given or adduced at the hearing may be under oath at the discretion of the chair. If the testimony is to be given under oath, the chair or another member of the committee designated by the chair shall administer an oath or affirmation to the witness at a hearing of the committee. The special committee is not bound by technical rules of evidence and may admit evidence that the special committee considers to be reliable, material, and relevant. The chair shall make evidentiary rulings, which may be overruled by a majority of the special committee members present. The decision of the special committee on whether to recommend articles of impeachment shall not be based solely on hearsay evidence. And a member of the special committee may be designated to lead the initial questioning of a witness after conclusion of of the witness's testimony, its initial testimony, other members of the special committee may question the witness subject to instruction from the chair respecting the timing, scope, and duration of the member's examination. The special committee shall record all proceedings in which testimony or other evidence is presented. Minutes shall be kept of the proceedings by the staff to the special committee, and then the special committee may allow witnesses to appear remotely.
Questions on that, those provisions? Yes.
So what is an evidentiary ruling?
So-
D2,
Mhm.
D sub 2.
So there may be questions from witnesses, from members, about whether or not testimony or records that you receive, documents you receive, should be relied upon by the committee in its determinations. And therefore, if those questions arise, there needs to be a determination whether or not they can be used by the committee, and that would be the evidentiary ruling or evidentiary determination, and that would fall to the discretion of the chair.
Okay.
As informed by the legislative council, almost certainly.
And this is not a new standard. It's a standard that's used in the ethics panel, at least, because trying to bind yourself by rules of evidence in this type of proceeding would be really difficult. You're going to have witnesses that may not be represented by attorneys. You want to receive their testimony. You want to encourage it if it's reliable material and relevant, and you don't want to get caught up in frankly rules that you may not have a lot of experience with, expertise on, etc. But you have the authority to set what the standard is, and you will work with us to determine what is reliable and relevant material.
And also, can you tell us, Michael, what hearsay evidence is, just so we're all starting at the same place?
Sure, it's evidence that the witness does not have personal knowledge of or witnessed specifically, but is only hearing or receiving through secondary sources. So if you told, well, just say, Tucker Anderson in my office told me that he spoke to someone in Franklin County and had anecdotal evidence about what occurred in Franklin County. What Tucker Anderson told me is hearsay evidence. It's not directly from a person who had personal knowledge or direct eyewitness of a situation.
So it's gossip?
It's one way to look at it.
So, okay, so it bothers me, this last sentence, recommend articles of impeachment shall not be based solely on hearsay evidence. So we are able to use it, but just not solely.
Yes, and that was a standard drawn from another state in its impeachment proceedings. I do think you may have people that have direct knowledge or were eyewitnesses, but you're also going to encourage them to talk about what they know about these situations. And so you may hear hearsay evidence, but you're also going to be hearing direct witness or direct personal knowledge. So it's not that every bit of hearsay evidence needs to be excluded or cannot be relied upon. You have to use both direct witness or personal knowledge to form your recommendation.
Okay. Thank you.
Representative Byron and Representative.
Thank you. With hearsay, is there like a statutory definition of that?
to work off of within?
There's court rules regarding hearsay.
Okay.
Yeah, so just seeing under D1 that there's the opportunity for folks to share under oath or not under oath. What would be some reasons of why somebody be under oath or not, or just, I'm trying to understand how it would be determined and what pros and cons. We can help share that, or should we just set a standard, everybody? I'm probably open up a can of worms, I'm just curious.
Well, generally, when you are taking testimony in the legislature, you are not putting witnesses under oath. So, which means there may be less confidence in the truthfulness or veracity of what you're hearing. So I think the idea, particularly if you're dealing with potentially a less friendly witness who is not excited about being here, you may want to consider putting that, having that person take an oath that they will be telling the truth, so that you can have more confidence in relying on their testimony.
So I would add to that there are going to be certain witnesses that are providing information to help us in our investigation. For instance, the Department of State's attorney, we're probably going to have witnesses from there to talk about policies that are involved. We wouldn't put them under oath. My inclination would be if it's any kind of factual witness about what happened, we would probably put them under oath. I think that's useful for down the road if we end up in a trial in the Senate, if that's where this ends up, having had testimony under oath, I think can be very important. So that's kind of how I'm looking at it. I did have another point, just as far as going back to the hearsay, with respect to Representative Brannigan's questions as well, and Mike didn't go down this path too far, which is good, but there are a lot of exceptions to whether hearsay evidence actually can be brought into a trial as well. So that's also why, say not solely on hearsay, that there can be hearsay. There are exceptions to hearsay evidence as well. And just one other thing is that that language also came from the ethics panel as far as the.
In all of the panel.
Yeah, in all the panels, we have that similar language. So certainly legislative council used to dealing with it. So, yeah, Representative McCarthy.
Would it be fair to say that during this investigative phase, there's going to be context and information that might not be really specific factual evidence, but might sort of point us in a direction? And so we want to really have the funnel of information be broad at this phase, but that some of the things that might spark interest or have us ask for a certain document or ask another person to testify, as this process moves forward, that the standard will probably get higher in terms of relying solely on specific factual evidence, but that we're kind of at the beginning of a process of trying to figure out what actually happened. And
Yeah, no, I think that's exactly right. I mean, that's why we don't have in here that there'll be evidentiary rulings on hearsay. We want to have it very open, but when we're getting to the point, if we get to the point of having articles of impeachment, if we want those to be successful at the next stage, which would be first of all, the vote in the House, but then if it goes to a trial, we don't want those articles of impeachment being based on hearsay, because their evidentiary standards presumably will be much stricter. And if it's anything like the 1976 trial, from what I understand, they looked to the rules of evidence. So that's why when we get to that final articles of impeachment, if we do, we want to make sure that that's based on evidence that the Senate will be able to look at that supports those articles of impeachment, if that makes sense. But early on, we want to hear it completely open, like Representative McCarthy says. Makes sense?
Thank you.
Other questions regarding this area? So I'll just point out one other thing before we move on. Where it talks about in D3, a member of the special committee may be designated to lead the initial questioning of a witness. So this is another place where it really points out the difference of what we're doing here versus in our normal committee work. That we may be having a witness and we're going to not just ask them to make a statement and we're going to ask questions. We want to be a little more directive on that. We want to have the testimony really follow what, we're trying to contain, not go down rabbit holes. Like if we're looking at a particular potential wrongdoing, that's what we want the questions to be asked about of the witness. So it's kind of like not leading, I shouldn't say that, that's the wrong word, but it's like asking questions of a witness that's on the stand, essentially, which is a little different animal. And for that, it makes more sense for an individual member of the committee to take a particular witness and walk them through that testimony to make sure we're covering everything we want them to cover. And then after that, open it up for anybody else that has any kind of clarifying questions of what that testimony was. So it's a little bit kind of a different animal than what we normally do with witnesses, if that made sense.
I think that's a good idea.
Yeah, so. All right. Anything else with respect to this? Doesn't look like it, so we'll move on. Thank you.
So in subdivision E, documents or other records produced or acquired by the special committee shall be open to the public for copying, except that documents or other records that are otherwise confidential. All that are produced or acquired by the special committee at a meeting held in executive session shall not be subject to the Public Records Act. So I want to talk about this a little bit. So as I said earlier, the General Assembly in large part is subject to the Public Records Act by the terms of the Public Records Act. So there are 220 something exemptions to the Public Records Act. And if you receive material that is exempt under the Public Records Act, you can assert that authority, and that remains your authority. It's not changing that authority. What this is changing is that when a document has been designated confidential, there's a distinction between exemption and confidential. When it's exempt, there is actually discretion of a public agency whether or not to disclose that information. When it's confidential, you can't disclose that information. And so what this language is saying, when you receive confidential information, or when you receive information during an executive session, you are going to treat that as not being subject to the Public Records Act. And that's important because when you receive a Public Records Act, something that is confidential under the Public Records Act or an exempt under the Public Records Act, you're required to respond that you are withholding that document. And you're required to identify what that document is and why you were withholding it. When you say something's not subject to the Public Records Act, you don't have to respond that you have that document, that and why you were withholding it. And that's important for purposes of an investigation because you want to encourage people, witnesses, to provide you with information because some of your witnesses might be directly affected by their testimony in their ongoing employment. And so instead of making those witnesses hesitate about testimony because they could be identified as providing testimony, you're saying, hey, that is going to be confidential and it's not going to be subject to the Public Records Act. And that's an important distinction that you should be aware of. That is how you handle ethics and sexual harassment claims under your current rules and procedures of those panels, because it's the same type of dynamic. You want people to be able to testify and feel free to testify without the possibility that their testimony or the records they provide will be disclosed, if only just the fact that it was a record that was reviewed. So moving on from there, minutes of the public meetings and the final report of the special committee shall be available to the public for copying. The committee may vote an executive session to include in its final report a document or other record produced or acquired by the special committee in executive session, except for records otherwise required to be kept confidential under law. Members of the special committee and staff shall keep confidential any documents or records that are confidential under law or that are produced or acquired during the meeting of the special committee held in executive session. So I've had experience with this before. You members generally are asked to keep this information confidential. If you do disclose it, there is actually disciplinary authority of the House to censure you for disclosing confidential information. I've never seen that censure happen, but it's a possibility. I have seen members disclose confidential information, and it's a very it's a challenging dynamic after that information has been disclosed, because there's a trust that has been lost. And so one of the things that I would encourage is that the members all kind of directly and specifically protect the confidentiality of the information that is confidential under this procedure.
So, and I would suggest logistically that we should get a confidentiality or confidential stamp so that we know which documents are confidential. And just for keeping track of things, I think that we should have numbered copies, and they'll be stored. You know, we have a place where confidential documents are going to be stored.
Sure.
So that nobody accidentally takes one home and finds it in the records 5 years from now, like we keep on hearing about our past presidents.
And that is the direct next sentence. It says, if a document or other record is made available to a member of the special committee during a meeting held in executive session, the member shall not remove or reproduce the document or record. And then any and all documents or other records produced or acquired by the committee during the course of its investigation shall be inventoried and stored as a special committee record. The special committee shall securely store all confidential documents or other records produced or acquired by the committee, including all documents or other records produced or acquired during a meeting of the special committee held in executive session. So it's contemplated that they will be inventoried, they will be stored separately, and they will be retained in a confidential manner.
Any questions on this section? I did have one question as far as if we take for a couple questions. First of all, if we are recording witness testimony in executive session, that would be considered document as well, right?
That would be a record.
Yeah. All right. So that would be held confidential. Do we have discretion? I know in here we're saying just for the final report, a document or other record that was produced in the executive session can be included. But what if we decide that, all right, we've done executive session witness testimony and it ends up that really there was nothing, there's no reason why we should have had that particular witness in the executive session. In other words, there may be reasons why we want to release something that we to the public record from executive session. Are we allowed to do that under this, or do we need to write that in here that the committee can vote to change a record that we're treating as confidential because it was produced in executive session to treat it as a public record?
I don't think you have specific authority underneath the procedure right now to do that. I think you would need to include that. My concern would be the witness and the expectation of the witness when they provided that information. So you may want to contemplate seeking permission of the witness prior to disclosure.
So if we receive permission from the witness you still need to add that kind of a provision in here, do you think?
I think you would want to be clear, if only for the witness's knowledge. When they come, you can point them to this section, subsection, and say, hey, this is how your testimony, your records are going to be managed. Please look it over. So they have an expectation or an understanding that even if they've testified in executive session, you may come to them and ask for permission to disclose that.
So I guess I'd just ask the rest of the committee if anybody has a view on whether that flexibility is something we want to have.
So I think that the concern that we might want testimony to be able to be shared or documents to be able to be shared if one of these cases moves to trial, it has to be weighed against the idea that even the possibility of a witness being asked to disclose something might limit the testimony that they're willing to provide during this investigatory phase. So I almost feel like if someone testifies or says something or discloses something during this investigatory phase that's really key, that we almost would need to recreate that during a future phase in order, for it to really be disclosed with the full knowledge of the witness or the person conveying that document at the time. Other people might have a different opinion about that, but I have concern about us.
Sure. No, there could be downsides definitely to doing this. And the more I think of it, the more I don't want to have that ability at this point. And let's see how it goes. And if sometime down the road we find that we really have something that should be public, we can revisit the rules and decide at that point.
Remember, the Senate's going to come up with its own standards of evidence and discovery and the ability to obtain documents that you are going to keep confidential, but they may be able to obtain through their discovery and evidence authority.
So I think at the end of this, we may need to revisit what confidential documents that confidential because they were received in executive session can be used at a subsequent trial if there is one. I don't think we need to decide that now or in the rules where we are now. Is that?
That's I think that's a valid statement. You have authority under HR 11 and this procedure to adopt further rules if you need further detail and specificity.
So we're good with where this is right now, so I think I'm reading here.
Okay. So in section F, any person who desires to appear before the special committee to give testimony and who is not neither invited by the committee nor compelled to do so by subpoena can contact a member of the special committee or any investigator that you appoint at least 24 hours before the scheduled hearing where they want to testify. And the special committee may permit a person to testify if it determines that they have relevant and probative knowledge or information regarding any matter subject to the investigation and that the testimony would not be redundant or cumulative. The special committee may, upon a vote of a majority of members present, require persons wishing to testify pursuant to this section to submit a written statement explaining the relevance and value of their proposed testimony to the investigation, and all of those written statements would be part of the record. Any person who appears before the special committee under this section would have all of the same rights, privileges, and responsibilities of a witness as provided elsewhere in these rules.
Any questions on that provision?
So are you concerned about people just wanting to come to be part of the show?
So I would want to make sure that people feel that they certainly can come forward with evidence and such. I mean, I don't want to suppress people from coming forward. And if there's a downside that more people are going to want to come forward, I don't imagine will be the case. That's why we've kind of left with the committee the discretion on whether to actually hear from somebody. I think this provision also it's open for the respondents. If the respondents have witnesses that they want us to hear from, they can propose through this provision to have us look at that. So that's an important part of this as well. Representative Bowman.
Because how else are folks, Susan says, any person who desires to appear who is neither invited nor compelled. So otherwise, we are deciding who comes. And we would give notice to those people through this whole process. But I'm just thinking, like, say somebody did come to one of us and be like, oh, I think I could provide information, or I want to. Like, is that part of a discussion we could have here too, to be like, this is?
Yes.
Okay, I'm just trying to figure
definitely.
out. So there seems like there's many different paths for it, but ultimately, if somebody isn't feeling like they're getting heard through our process here, they have a opportunity to do it. This kind of make sure there's a process.
Right, yeah, they could reach out to any of us, and we would bring it to the rest of the committee as far as suggested witness. Other questions or comments on that provision?
Sure.
Right. G says that at the conclusion of the presentation of evidence in each matter, the special committee will issue a final report to the House, which must contain a summary of the pertinent evidence and applicable law and a recommendation regarding whether sufficient grounds exist for impeachment. Was there? Last one.
So we don't specifically say here that we would draft the resolution with articles of impeachment, but I think that's implied and understood from the House resolution anyway.
Right, I think there are, so the language in the resolution is that you report to the House such resolutions, articles of impeachment, or other recommendations as you deem proper. So, so you could propose, you could introduce a resolution with articles of impeachment. You could introduce a resolution that suggests further inquiry before articles of impeachment. You could recommend that the House continue to pursue, and that the standing committees look at introducing a resolution. I mean, I don't think your options are resolution with articles of impeachment or recommendation against. I think you have to figure out where as a committee you are at the end of your investigation.
Right. It may not be the committee that is sponsoring the resolution. Right. It could be an individual committee member. Hopefully, if we get to that point, it would be unanimous. But
right.
So I think requiring the resolutions in this provision might in fact not be the approach. So I think it's fine what we have here. Right,
and I think what you had talked about with Betsy Ann earlier this morning was also if the recommendation is not to pursue articles of impeachment, then there would be no resolution proposed, or likely no resolution.
Questions on this provision? I don't see any. Okay.
Right. And then finally in section H, the special committee may, with a vote of a majority of the members present, adopt additional rules and procedures or modify these rules and procedures as you deem necessary for the fair and efficient conduct of your investigation. So you're leaving the door open for revisions of additional rules and procedures in the future.
All right, appreciate it. So anything that people think is missing in these rules, and all right, it's a little hard to just right off the top of our heads to do that, but so my thought on this is that at our next meeting, our first order of business will be to vote on this or to have any kind of changes that we may want. So people will have this. I'm looking ahead. I'm planning on suggesting that our next meeting will be a week from this Thursday. But our first order of business, we could vote on these rules and proceed under these rules at that point. I'm wondering if in the interim, if something comes up, should they go to me and then to you in case somebody has an amendment to the rules that they want to have us consider a week from Thursday? What would be the best approach for that?
I think that makes sense. I think to run it through you, or if a member wants to talk to us first to decide if it's covered by the rules or whether something makes sense, they're certainly welcome to reach out to us as well, but we want to ultimately have, I think, the chair in loop.
That sound good to folks? Give everybody a little bit more time with these two. All right. So we have one more piece of business, I believe, and I'm just looking at this, and we can take an hour, just plug through. What's the will of the committee? Is this going to be like an hour-long explanation of finding an investigator, or is that?
Only if you make it.
Touche. So why don't we just keep proceeding then?
Very like grizzled legislative counsel who's been through lots of hearings.
Exactly. So before we get started, just real, a little more context. So we're at a couple different places with these two respondents. With respect to the state's attorney, we have an investigative report. It's not ours, but it was done by the Department of State's attorney. Had it contracted through Paul Franklin Collins. So we have kind of a starting point to look at in that particular matter. And I think one of the next steps will be to dive a little bit more deeply into that memorandum, that report that came out from Paul Franklin Collins. That would probably be at the next meeting that we would do that. And it may be under executive sessions, still to be determined. But in any event, the other matter with respect to the sheriff, we don't have that. And I think we really do need an investigator for at least that particular matter. But we may also need some special outside counsel to assist us with each of these matters, because getting prepared, doing an investigation is new to all of us. And we may need to have somebody else to help in preparing for having witness testimonies, et cetera. So I just want to give you that context, and that's why we're going to have Mike talk a little bit about the process and whether there's any difference in process between an investigator or if we wanted to get a special counsel to help with something more general.
So Mike, can you log into the Zoom? Okay, great. And can I share? Okay, great. Thank you. So Becky Wasserman is generally our contracting attorney, but before Becky took the role, I did the contracting, and I also do the contracting for the individual investigatory panel that I serve. And so there's some just general concepts to think about when you're going to do contracting. So the General Assembly is not bound by the contracting requirements of the executive branch. There is no specific procedure that for contracting that governs the contract that the General Assembly enters into. However, the General Assembly closely follows the contract requirements for the executive branch for multiple reasons, such as limiting contract use, limiting liability, and reducing costs. And also, if there's ever an issue with the contract, you want the Attorney General to be comfortable in defending that contract. So you want to use the principles that the Attorney General has recommended that the executive branch use. However, there are circumstances that, and generally state of Vermont employees should be used to perform essential government functions. And I think you all understand that concept. But there are circumstances that justify use of contractors rather than employees. And once a determination has been made to enter into a contract for service, applicable state law and the policies and procedures may apply. You might have certain tax obligations. You might have certain workers' compensation requirements depending on the type of contract. And so contracts for service are categorized into two types: personal service and non-personal service contracts. I believe you're talking kind of not intuitively about non-personal service contracts, which generally have the characteristics of an independent contractor. And where the state only has the right to control or direct the result of the work and not the details of what and how the work will be done. So examples include doctors, lawyers, accountants, construction contractors, stenographers who exercise a high degree of independence in performing their services and are independent in trade, business, or profession in which they offer services to the public. So that sounds like private investigator or a special counsel. That's the type of contract most likely you are looking for, a non-personal services contract. A contract for personal service contracts generally have the characteristics of an employment relationship where the state or the General Assembly will be directly supervising each and every action by the contractor. And that triggers state and federal tax and labor law requirements. And I don't think you want to pursue that type of contract. So generally, competition in the procurement process is encouraged, if not required, in the executive branch. And the executive branch uses something called one of the administrative bulletins. Do you all know what the administrative bulletins are? The Agency of Administration has issued these. Basically, they're procedures directing how certain actions are undertaken by an executive branch agency. When they issue a grant, this is how an executive branch agency issues a grant. When they enter a contract, this is how you enter a contract. And so Administrative Bulletin 3.5 is that procedure, that guidance that the Agency of Administration has issued that state agencies follow when entering into a contract for procurement and otherwise. So competition in that procurement process is highly recommended in Administrative Bulletin 3.5 because it serves both the state and potential bidders by ensuring the procurement process produces an optimal solution at a reasonable price and allowing qualified vendors an opportunity to obtain state business. And in addition to complying with existing statutory and regulatory requirements, procurement must comply with following general principles. It must provide notice, an appropriate notice of opportunities to compete for state business. And that's going to be something we'll talk about in a minute. It needs to have predictability. It has to provide a consistent process while conducting the procurement. And we'll talk about that too. It needs to be transparent, document the procurement process clearly and consistently. And it needs to be cost effective. So ensure procurement processes are designed to secure optimal solutions at a reasonable price. So those are the general principles of what you're going to do. But then there's specific directives in Administrative Bulletin 3.5 and what you may want to do for how to go about achieving or ultimately signing a contract. For a contract that's estimated not to exceed $100,000, the state may choose to follow what's called a simplified bid or a standard bid. For a contract estimated to exceed the $100,000, the state is required to use the standard bid. The standard bid process might be more commonly known as the RFP, the request for proposal. And that requires that a agency document what they are looking for. They put it out there for notice for a specified period of time. They solicit bids during that period. They have defined criteria for bid evaluation and contract award. And then they have a public bid opening and a public bid award. It can take a significant amount of time, usually depending on the scope of the contract being sought. Now, use of sole source or no bid contracts is contrary to the competitive process. You don't have a competitive process if you have no bid. But sole source contracts have been used. The General Assembly does not have a policy for use of sole source contracts, but Administrative Bulletin 3.5 includes certain justifications for executive branch sole source contracts, such as an unusual and compelling urgency, such as when health or public safety is at stake, or situations posing extreme financial consequence to the state, legislatively mandated situations, and required by a warranty or proprietary license agreement. Those are not limiting. You can use a sole source contract otherwise. And we'll talk about that in a minute. The General Assembly does use sole source contracts usually for anything under $10,000. If we have a known contractor that we know knows this building, and this is a strange building, facilities wise, we like to use those people because they understand how to work in this building and what we need to do. And so we will, if it's under 10,000, we'll enter into a sole source contract with them. It's good for them. It's good for the General Assembly. It's good for the building. If it's a sole source contract is expected to exceed $25,000, Bulletin 3.5 requires approval from an agency head. In the General Assembly, that approval will be sought from the office head, the head of the legislative office that's seeking the contract, provided that the General Assembly's use of a sole source contract for over $25,000 is rare. It's not that it's never happened, it's just that generally the processes that Becky has implemented since she's been here, really we use a bid process in most of the contracts over 25,000. And what we generally use is called the simplified bid process. And the simplified bid process may be used if the anticipated contract amount will not exceed $100,000. Most of our contracts don't exceed $100,000. And a simplified bidding process requires the state to develop a scope of work that identifies the work to be performed, the specific needs to be addressed, for the product to be delivered, and it solicits the price quotes from at least 3 potential vendors known to provide the specified services or products. It does not require a public bid posting or a public bid opening or a public bid award. But with that said, I would recommend that you develop criteria for how you are going to evaluate bids and how you're going to award. The criteria don't need to be very detailed. We generally come up with 2 to 3 categories, criteria, and we give them a weight in the evaluation process. And that's generally what we do. So we have a record of who bid, the details of their bid, and why we awarded the contract. There's also a bunch of general provisions that you need to be aware of what's restricted in any state contract or should be restricted in any state contract. You can't require the state to indemnify a contractor. Indemnify means that the state is going to pay the contractor for some liability that the contractor incurred in performance of the contract. That is actually an appropriation, and you can't appropriate money without the approval of the General Assembly. So we don't do indemnification, no indemnification. If that's in a contract, that's like an automatic request from our office to remove it. You can't require the state to submit to binding arbitration or waive the state's right to a jury trial. We're not going to give up the ability to go to a jury trial. You can't establish jurisdiction in a venue other than the Civil Division of Washington unit. You know who loves to do that? IT companies. They want you to have a venue in like Monrovia, California. And the Attorney General doesn't really want to go out to Monrovia, California to defend a contract. So the venue is in Vermont, in Washington unit. You can't waive certifications regarding tax status, child support, use of state funds, or equal opportunity clauses. And those are requirements of what is called the standard terms and conditions, which I'll talk about in a minute. You can't restrict the ability of the contractor to hire state employees without the prior written permission of the Department of Human Resources. You might be thinking, what is that about? You know, what happens or can happen is that somebody retires from state service and the contractor says, oh, I'm just going to hire that person. That person knows how to do what this contract requires. Well, that If that's the case, then it should probably be done by a state employee, right? And by the person that took the job that the retiree just left. So that's why HR generally is required to review that type of contract when you're going to be using an employee of that kind. You have to designate a governing, you cannot designate a governing law other than the laws of the state of Vermont. You can't waive the immunities, defenses, rights, or actions under the state's sovereign status. IT companies love to try to do that too. And we push back on that. And you can't limit the time within which a legal action may be brought, and you can't include something called an evergreen clause. You probably have evergreen clauses in contracts you've signed for your, like, I don't know, for your Verizon or your Xfinity, or, you know, it just automatically renews. Magazine subscriptions sometimes too. You may or may not even get a notice that your contract has renewed, but we don't include those.
It changed that a lot.
And then all contracts must adhere to the standard state provisions for contracts and grants, which I'll talk about in 1 minute. And that is part of Administrative Bulletin 3.5, which we just talked about. So let's talk about the practicality of how you're going to do a contract with a consultant, investigator, special attorney, counsel / If you're following the simplified bid process, the committee or delegates from the committee would develop a scope of work and identify 3 or more potential contractors from which to solicit bids. And the key questions at that point are really what the scope of the work. What are you asking them to do? And in what time frame are you asking them to do it? The last investigation contract we entered into, we had a pretty specific scope of work and a very, very, it was a pressing time. We gave them less than a month to complete the investigation, and they did it. So you might want to think about what timing you need for whatever you are going to request as a scope of work. Then the committee solicits bids. Once you have your scope of work and what timing you want, you solicit bids. And there are companies, contractors, law firms that probably fit your needs for both of the investigations. And we can talk to you about who they may be. The potential contractors who display an interest will be interviewed. If interested, the contractors submit bids. The process can take 2 to 5 weeks. I will note that the bids can vary significantly in expense depending on who you are talking to. The hourly rate of one attorney might be significantly more than the hourly rate of other attorneys. So you may want to talk about how much you are going to allocate or earmark for any of these contracts. If there are multiple bids, the committee or delegates would review and score the bids based on evaluation criteria. This can take a day or two. The contract then needs to be negotiated. The contractor has worked with the state or the General Assembly in the past. It can be completed quickly. It can happen in 1 or 2 days because they know what the standard terms and conditions are. They complied with the standard terms and conditions before, and they're like, oh, that's no big deal. We'll do it. And so then it's really about scope of work and timing in the contract. And they've already looked at scope of work and timing because that was part of the bid process. So when they have experience with us in the state, it's usually a pretty quick process to get to a contract. If they don't have experience with the state, it can take longer. And contractors who are inexperienced with state work or have concerns about provisions in the standard terms and conditions often ask for revisions to the standard terms. And why would they do that? Because when you look at some of the standard terms and conditions, it may not really be applicable to the contract you're talking about. For example, you need automotive liability of $1 million. And you need a general compensation liability and property damage of 1 million for each occurrence and 2 million for general aggregate. And so if you're entering a contract for like $30,000, is it worth it for you to get a $1 million automotive policy and a $2 million CGL? So that's some of the people that don't have experience with the state and aren't really in this ongoing business. They really look at them, they're like, whoa, wait a minute. And we have waived some of these provisions in the past when the person's here, they're not using a car for their services being provided. We generally ask them, do you have your own automobile insurance? So that like if you drive into the State House, like literally drive into the State House, that we and they do. And so we have waived that provision before. But then there are others that really concern people and that you're not allowed to waive. You can't waive the set off under Administrative Bulletin 3.5. And that says that if the party owes, the contractor owes the state money, that any payment under the contract is going to be set off by what they owe. And some contractors really don't like that. You can figure out why. You can't waive the provision about how they have to come into compliance with taxes. You can't waive the provision about them being in compliance with their child care payments, et cetera. And they can't waive the remedies, the warranties of right that the state has as a sovereign. So those are the standard terms and conditions. We attach it to every single one of our standard contracts, just as state agencies do. And again, when we're dealing with a contractor inexperienced with the state, that can take a little bit of time to negotiate. And then the other practical consideration in the terms that the contractor wants. Usually with attorneys and investigators, that's not really a concern. But when you talk about IT firms, and when you try to negotiate with Apple, they're like, no, we don't negotiate. These are your terms. And so states have actually bound together in what's called the Western States Alliance to agree for terms to work with Apple. We're not part of the Western States Alliance. So we have to work with Apple in like this whole really convoluted way. But I won't go into it. Hopefully you don't have a contractor that's bidding that has those specific types of demands in their contract. I expect that you won't from my prior experience, but you should know that that can be something that can affect the timing of a contract as well. So I think my big takeaway for the special committee is to come up with the scope of work. What do you want this contractor to do? When do you want to do them to do it by? And how much are you willing to spend for each of them?
All right. Representative Owen.
Thank you for this. Maybe you covered it and I missed it. Is the contract process confidential? Is the ending contract public record? Anything we need to consider with that?
Generally, what we do is that the negotiation and the drafting of the contract is confidential. Once the contract is signed and awarded, we have made it public. Frankly, I haven't received many requests for a contract. I know JFO has. I have received contracts from the other bidders to get the evaluation criteria that have been used and why the contract was awarded to one bidder versus another. And that's why we have a little matrix that we use. We can just give to people when that happens. But that's, yeah, generally we would make it available. We don't, affirmatively post it, but if it comes up, we would provide it.
The final, whatever was awarded, but the process before that.
Yeah, and that's covered by a Public Records Act exemption.
Right.
So how specific does the scope of work have to be?
That's a good question. It doesn't have to be incredibly specific.
So if we were going to say, would it be too general to say scope of work is to investigate possible financial improprietors or other mismanagement of Franklin County Sheriff?
Yep. I think that is appropriate. Having a standard that they're investigating to or reporting back to you on, I think would probably be requested by the contractor. What level of evidence are you trying to find? What documentation, et cetera, what action? I think that doesn't need to be incredibly specific. It can be fairly general in nature.
So I'm inclined to delegate a couple of individuals to work with you. The question is whether the committee would need to vote on the scope or by delegating to a couple members. Because if we're not meeting again for a week from Thursday, I just want to get this process moving as quick as possible, particularly for the Franklin County Sheriff. That one, we need to get an investigator engaged as soon as possible.
So I can give you a draft scope of work. I could probably give you a draft contract pretty quickly.
So it's a matter of getting that, well, it's a matter of getting some folks interested in the work as soon as possible. I would think that if there's more than one, I think the whole committee needs to decide on the particular investigator and such, but I just want to move this along to actually get the request for proposal out there as soon as possible. So
I can get you a draft by Thursday.
So I was hoping that Representative Dolan and Representative Byron would be willing to work with Mike on that, just to get the RFP out. If people are comfortable with.
So just to clarify, you wouldn't be doing an RFP per se unless you wanted to go through the standard.
No, I'm sorry. Whatever we need to reach out to individuals, the simplified version, right?
Sure.
Whatever we need to start that process,
Yes.
that includes the scope of.
Yeah, I believe we're talking about the simplified bid
Yeah,
process
the
at the moment.
Yeah.
And then what the next step would be is who are you going to contact?
I was hoping you'd have the list of those that you've used in your.
I do have a list, but it's also something that you might want to provide input.
Yes, if we have any ideas, give them to our delegates.
Okay.
By the end of the week. And I'm thinking just, at this point, I've just talked about the Franklin County Sheriff one. I think some more thinking has to go into what we need, if anything, on state's attorney matter. Unless you think we're.
Well, I guess the question would be, Mr. Chair, if we want to, as you said, sort of begin with looking at the Paul Franklin Collins produced report that the department got and taking testimony and doing our own work to sort of figure out
Yeah, I think we'll need to dig into that report before we decide if we need more assistance in that one. We know that you have to get going on the Franklin County Sheriff one, so. That make some sense? Timing, if we're gonna give them a timing for wanting to have a report back. If that's something we're gonna need for this right away as well. I will throw out a time frame, and that would be end of July. Is that? I mean, I think we have lots to do in the state's attorney component between now and then, and we can focus our efforts on that as we wait for the investigative report. Does that sound like a reasonable?
I think it's a reasonable timeframe to start with, yeah.
And I don't know how much money I'll have to talk to somebody who has.
That will probably be directed by response from the contacted bidders. Just as I said earlier, it can vary widely. You have some firms that will say, we're going to have a principal, secondary, 2 associates, an investigator, and 3 paralegals work on this. And then you'll have one that'll say, I'm going to have 2 investigators work on it. So that's obviously a significant difference in cost.
Correct. Yes, Representative.
And because we are going with the simplified bid process, that has the ceiling of 100,000.
Yeah.
That automatically creates that
Yeah.
report. So
Yeah.
you're saying it could be, we say you can't exceed 100,000, but we get different bids
Yeah,
ranging from.
yeah. And you probably want to put a cap in regardless of who you contract with. Because that's just how much money that the General Assembly has to spend. I don't know. And so once you get an idea of what the bids are, what the rates are from the bidders, you can probably seek approval from those that be for the money.
So to be clear, we're being tasked with starting this process and getting this out.
Yeah, working with Mike to.
Okay.
Put together a package to come and present to it.
Well, that's what I want to clarify. Does it need to come back, or are we saying we are going to implement the process?
So I would like this process not to have to wait until next Thursday. So yeah, you're given the go ahead. And actually, if you can run it by Mike, so we're still not at a quorum. That makes sense.
Yeah.
Yeah, you're to lead the charge, but just check in with Mike to make sure that looks good. Yeah.
Has there been an appropriation for this?
Not a specific appropriation, but the appropriations committee looked at what we have in, I don't remember what fund it is, but they did report on this when we had the resolution on the floor. They had looked at the resolution, they had looked at whether there is funding. I don't know what the amount is off the top of my head.
No, I think we should try to keep the scope very specific and narrow, because this is, I believe their conversation revolved around sort of discretionary legislative budget that's, in our office over here, which is not, but it's not a lot of money. That's the, what funds, legislative activities that are outside of, the speaker needs to take a trip to a conference somewhere and those sorts of things. So this is not, it's not a huge budget.
No. Yeah, Representative.
Just looking to confirm from the whole group of that we all agree that we're moving forward with this. Like, do we need to vote on it? Or I just want to make sure as we're starting this process, like we're starting it and it's getting these bids out, that we're just kind of starting off of a place of group consensus.
Mike has an opinion.
So for some of the other panels, what is done, there are delegates that go out, or maybe it might just be the chair that is interviewing the bidders. And then we produce the evaluation matrix, bring that forward, and the delegates or the chair recommends to the full body who they should contract with, and the full body votes and approves.
Okay. So that's what we would be doing. We would be coming back with the
Yeah.
recommendation of,
Yep, this is who we recommend.
yep,
And then the full body can say, oh, well, what about these persons? They can say, no, we don't want to do them because they don't have the time, or they only have 3 people available in the next 45 days or something.
Good?
yep.
That work? Anything else on this particular topic? I'm not seeing any. I think, we will schedule again to meet a week from Thursday. I don't know what that date is. June 1st, at the same time, 9 o'clock.
Mr. Chair, I have a doctor's appointment that I have to go to.
Okay, yeah.
I can be here by 11, but it doesn't bother me if you guys want to start and work through for a couple of hours. My appointment is in Barry, so I'll be here by 11.
And we will work on the agenda, and probably what we will be doing in the morning will be public anyway, and we'll be on Zoom, so you'll be able to catch up.
Oh, good, okay, fine.
Make a point of that. But we will work on the agenda and have that out by the end of the week. So. Anything else?